Hello again, this is Grant Swartzwelder, President of OTA Environmental Solutions, and welcome to another episode of Oilfield Strong. I was recently up at Albuquerque and fortunate to have as a guest the Executive Director of IPANM, Jim Winchester, but there were a lot of fantastic presentations at the event, Jim, but one that really stood out was a panel that you had on the rulemaking that is being done. And it seemed like there was an effort to make a lot of changes that really inflict pain on the New Mexico oil industry. And they might not have had success. So now they're trying administratively to do a lot of things that could really hurt from an economic standpoint, a lot of the small or large producers. And so I know we've taped that that we'll be showing right after this introduction, but I'm so glad you're on to kind of give context. I think IPAM should be really thanked for all that y'all are doing to really make people aware, and that's the purpose of this video, as you know, and so I'd love for you to give an overview of what's going on with this rulemaking. We obviously have Drew Cloutier to well coming up, but then also a call to action of how the industry, once they know what's going on, surely they're going to want to do something about it. And I think IPAM would be a fantastic mechanism for that. So with that, Jim, welcome. Can you share kind of what's going on with this rulemaking and kind of, I know Drew will go into some of the details, but you could, I think, frame it for us.
Certainly, and thank you for the introduction, and thank you for joining us. Our annual meeting was July 9th through the 11th in Albuquerque, and had a fantastic turnout. And you mentioned one of our legal roundtable sessions. And I think it was important for us to talk to our members about all of the various fights that we're engaged with right now, specifically on the state level. We have over the past 6 years maybe been engaged with about 10 different rulemakings where we've actually intervened and had legal counsel representing us. Over the course of the last year and a half, we've added perhaps about 8 more different separate rulemaking hearings that are upcoming that we are now intervening in. I think the one that is really grabbing the most attention for us and our members right now is there will be an upcoming rulemaking hearing starting in October in New Mexico for new financial assurance requirements. And it's a large package that was attempted several times to get through legislatively and failed. Because wisely, even though the legislature tends to be progressive, there was enough common sense there to hold back some of these financial assurance requirements that were being proposed. So the administration has pivoted now and is doing this through administrative rulemaking. The petitioner is the Western Environmental Law Center, and they're stationed out of Santa Fe and very active and frankly, want to see more regulations in the oil and gas industry. So in particular, I think, the upcoming video will speak for itself, and our lawyer, Drew Cloutier from Hinkle Shanor, sort of setting up the various parameters in this rule. But the bottom line is that we're throwing everything we have at this. Financial assurance has the potential to really damage the small independent producers and force them either to go out of business or to seek doing business in other states, and really threatens the secondary market of well lives. So that is really sort of the lead-in into this rulemaking hearing and why Drew and others joined us to sort of explain what's going on.
No, I think that's a fantastic overview. And if anyone, after seeing this video, I would think they'd be wanting to get involved or to help. Are there areas that they can do that through?
Yeah, certainly. And in fact, we made the request out to membership at that meeting if the small producers who are willing to offer testimony to basically explain economically what it would mean if, say, $150,000 well bond per marginal well became the new rule and what that would do to them. We have about a dozen smaller producers that are going to be testifying and involved in this hearing, but there's power in numbers. So the call to action would be, please reach out to IPANM, get engaged both as a member, but also we are still looking for more folks who might be willing to actually come and testify, and at the very least, if not testify, dial in and make public comments during the 3-week hearing, which starts on October 20th.
Fantastic. And I'll make a plug so that you don't have to, that IPANM do not only on this issue, but many others take a lead for the New Mexico industry. So I think think about being more involved financially or just with your time. And I'm sure you would be more than happy to accept that. A quick introduction about Drew Cloutier. He is with the Hinkle law firm in Roswell. Partner with them, has been president of a variety of boards, very well published in a variety of technical and legal journals. Fantastic representative of the industry. So you'll see from this video that we're in good hands, and he'll provide a very good insight of what's going on. So enjoy the presentation that Jim and Drew are about to provide. And
oil and gas industry as a whole, this rulemaking is probably an existential threat to many of you and your businesses going forward. Colorado had a similar rulemaking, and they're predicting they're going to be down to 9 operators in the state here in a few years. The big issue is financial assurances. Without legislative approval, they want to define a marginal well as being one that produces less than 1,000 BOE in a trailing 12-month period. Gas is going to be counted at 6 MCF per barrel for BOE calculation purposes, and it produces less than 180 production days. The and is important because if you've got a gas well that produces more than 180 days, you don't have to worry about what your BOE is. But it's a 12-month trailing. That is, you're going to have to look at this every month to determine if your wells are qualifying as marginal or not. And once they're marginal, they can never come back from effectively being marginal, because you're going to have to post an individual well bond of $150,000 to provide financial assurance that at the end of the day, you're going to come up with more money to plug and abandon the well, and then someplace down the road.
And that's per well, $150,000 per marginal.
Per well.
There's no blanket.
And if an operator has 15% or more of its wells as marginal, they have to bond every well. At that level. Restrictions on becoming an operator and transferring to another operator that are pretty extensive and really involve the OCD becoming a mini Securities and Exchange Commission. If a person in the operator or is an officer, director, or partner, or a greater than 25% owner in the past 5 years of another operator that was out of compliance, can't do it. So your VP of land was vice president of land at some other operator 4 years ago. 3 years later, that other operator goes out of compliance. You're not eligible to receive a transfer. They are allowed to, you're going to have a PMA plan certified by an officer, director, or partner to become an operator or transferee of another operator's assets. And the OCD can request credit rating information, financials, long-term liability report, reserves and economics reports, historic decommissioning costs, estimate of decommissioning obligations in the future, and your history of inactive wells and returning inactive wells to production. And additionally, if you're a multi-state company, if you're out of compliance with the quote oil and gas law of federal oil and gas law or the oil and gas law of another state, no clue what that law means, whether it's OCD-like law or whether you've been sued for royalty underpayment, you're also not eligible. There's an addition of the concept of beneficial use to oil and gas, which is a brand new concept. It is really a concept of moving wells into P&A status because there's going to be a 3-year restriction essentially on temporary abandonment status. After that, you have to get specific division approval with plans as to what you're going to do with the well to continue TA. But basically, if you've not produced for 90 days or not produced 90 BOE in 90 days, there becomes a presumption that your well has no beneficial use. And anything in addition to the requirements that are there right now, you're going to have to leave your isolation devices installed for your mechanical integrity test in there for the life of the TA status, and do caliper log and casing integrity tests. So that's the rule.
Then this was filed, how huge this is for independent operators. And as he mentioned, the Colorado situation about where they're going, because their similar rule was enacted several years ago, and now we're feeling the effects of that, including, I think some of the stats that we pulled together show how abandonments went up dramatically as soon as the higher financial assurance rates went into effect. And that's a real tragedy, because frankly, those wells that are out there in compliance are still actively producing, and not only helping those operators to continue their operations, but providing revenue for the state. So this is as big as it gets. And
to sit and reflect on this particular rulemaking effort, it strikes me that this is a sophisticated group. This is not the first time they've come at the Oil and Gas Act trying to make additional burdens on industry. And so I think that what kind of concerns me the most about this rulemaking, beyond just the financial assurance requirements and those changes, is the way that they've crafted the various definitions. And they're doing that so that they can essentially box us in certain parameters that then gives OCD greater authority to require essentially whatever they want on industry, because the definitions that they proposed are vague enough and broad enough that they can essentially act as they see fit. And I think that's particularly dangerous, especially in a state with the political climate and the stance that much of New Mexico has towards one of its most, if not its most important industry. And so I think the effort here is we need to really make sure that the commission understands and the regulators understand, look, if you want operators to assemble data when they're operating in 20, 30 different states, A, that's a big effort. B, the folks that are in New Mexico doing work for a large company, are gonna have to go figure out who's doing what in other jurisdictions, get them to get the data. And then it becomes a question of what is OCD actually going to do with that information, simply for the purpose of actually deciding whether or not they're going to allow a change of operator to take place. So that's one high-level example that I think causes folks a lot of anxiety. Another issue is the Western Environmental Law Center is trying to conflate oil and gas with other areas of the law with terms like beneficial use. And if you think about beneficial use, what does that mean? It can mean essentially anything. And if you're a third of the time water lawyer like I am, it's a loaded term and a term of art in New Mexico water law and Western water law. And so if that is tied, and if cases pertaining to water then apply to oil and gas with respect to how you deem something is beneficial or not, it can have far-reaching implications. And so I think the effort is really to delimit as best as we can and clarify the rules and their applications so that they are not just taken and used to really rake us over the coals for years on end. And so specificity and clarity is really critical. We have some really great witnesses lined up that I think will help us make our case, but we also need to be realistic that OCD wants this rulemaking to deal with some of the important issues that they do have issues with industry on. So this rulemaking is going to happen. We are going to get some sort of rule, and we just need to make sure that it's as sensible for the industry and for the regulator as possible, and doesn't give OCD carte blanche authority to just mandate whatever they want, because the rules that they're proposing are